I will be your chair today, so at the seminar, and we're happy to keep going with our new perspectives on Russian Eurasia seminars here at the Aleksanteri Institute, University of Helsinki. And today we have a guest speaker, Dmitry Kurnosov, who is a Carlsberg Fellow here at the Faculty of Law, University of Helsinki. And maybe he will say a couple of words about his biography later on. So, and this is a very interesting and unusual seminar because maybe for the first time we don't have social or political scientists speaking. So this is a specialist in legal studies. And I think it's wonderful that we can make this bridge between classical studies of electoral integrity, classical for us, I mean, political scientists, because this is the the academic gang I'm representing today. And I think it's great that we have so much in common to talk about. So, and I will be at the same time the discussant. So, and during my the time when I will be discussing, so I will ask Helena Gorbacheva to watch the timing, keep an eye on that we actually keep going and respecting the time frames we set up at the beginning. And hopefully everybody who wanted to join have already done this. So I see some familiar last names, and I hope we will have more participants. So feel free to ask your questions and leave your comments in the chat or just raise your hand. So because we don't have so many participants today, so we have plenty of opportunities to have a proper, I would say, voice conversation instead of exchanging messages in the chat. So please feel free to use this option. And without, I don't know, should we wait for another couple of minutes, or we just, without any further ado, we will begin the talk. I will give a floor to Dmitry Kurnosov, and just in case, let me warn you that this session is going to be recorded, and in a while will be posted online on our project's website, Aleksanteri Institute, and as well as the internal intranet of the University of Helsinki, Unitube. So if you're okay with that, so please stay with us. If not, so okay, hopefully you're not. Okay, and let me give the floor to Dmitry. So the floor is yours.
Thank you very much for inviting me and for your introduction. So, as Margarita told you, I have mostly a legal background, but in a way it was always intertwined with political and election issues. So, yeah. So first of all, a bit of a background, starting from the way from time long before. So, yeah, it's been almost 10 years since I've joined the Russian Constitutional Court, which is based in St. Petersburg, and I've worked there for 5 years, and these years, 2011 to 2016, well, they were in large part defined by elections in 2011 and aftermath, so the protest, and in a way, those elections and those protests, they thrust the issue of election integrity to all sorts of forms, including the legal arena and including the constitutional court. So perhaps the most well-attended court hearing in the history of the court, at least during the past 20 years, was actually the hearing about election law, not that the eventual judgment turned out to have serious impact on the state of election integrity, but it certainly showed that there was certain public interest in this kind of issues. So from that professional experience, from that perspective, I moved to the University of Copenhagen, where I did my PhD research, finishing my thesis and successfully defending it in February 2020, so just over a year ago. And my thesis project largely focused on how the European Court of Human Rights, so regional human rights court, how it dealt with the various issues which arise during and after election campaign. So basically what I did during my PhD project was to develop a normative model of how the European Court of Human Rights deals with election issues. And on this topic, I will share a bit of my thoughts today during this presentation. Finally, starting from this year and for the next 2 years, I will be a target fellow at the Faculty of Law here at the University of Helsinki, and my project will be natural continuation of what I studied during my PhD project. That is, I will look into what is actually an impact of the judgments of the European Court of Human Rights in the field of election law. What is their impact on the situation on the ground, so to speak? So if those judgments made by European judges, if they affect how elections are actually run, if they affect administrative conduct and election dispute resolution and various other interconnected issues. And I will look into that specifically across the range of different political regimes which exist in Europe and which are all under the jurisdiction of the European Court of Human Rights. So these are very different countries, so which from Finland to Russia and so on, but they should be theoretically guided by the same general principles. And speaking about the issue of election integrity as general, what has always struck me and what Margarita has nicely noted in the beginning is that indeed there's this kind of interdisciplinary dialogue, but it's kind of peculiar because what we see actually and what can be evidenced by this reference made by rather influential scholar of election integrity, Pippa Norris. So basically political scientists, they tend to refer to certain global norms and universal standards when speaking of election integrity. So in a way, they are basing their conceptual vision of election integrity on certain legal standards in international human rights law. However, there is little sort of concurrent action on the part of legal scholars. So compared to very active research on election integrity in political science, the field of legal approaches to election integrity is still, I would say, developing. So there is a bit of mismatch between the two disciplines so far. So I see my mission in a way to try and bridge that gap. And if election integrity is based on global norms and universal standards, as a legal scholar, the first question one would ask would be, what are the sources of those norms? And here, actually, we have to dig in a little bit into the way international human rights law functions. So, effectively, there is what legal scholars tend to describe as hard law. So these are norms which are actually binding on the states. And there is soft law. So these are more kind of recommendations. So those are meant not to bind states, but to persuade them. And what we see if we look into how the standards of election integrity are developed in international human rights law, we see that there is a large body of soft law in the forms of various recommendations, codes of good practice, remarks by international election observers. But at the same time, there is rather brief and very open to interpretation language in the hardware, in the binding instruments. Although at the same time, if read carefully, one may say that all that is needed is there in the binding instrument. So, for example, if we look into the International Covenant for Civil and Political Rights, which is the global human rights document, which was signed by practically all the UN member states, so which is nearly universal standard. What we see there is that there is both right to vote, right to be elected, and also a substantive standard. So there should be not just any election where people will be able to vote and to stand for office, but also these elections should be genuine. So in the sense that the will of the voters should actually be respected in terms of the outcome. So at the very minimum, this norm actually means to guarantee elections free from fraud. The same construction can be found in the European Convention of Human Rights, which is actually drafted even earlier than the International Covenant at the UN level. So what we see here are the same two elements. So there is the right to vote, but also there is the expectation that elections shall be genuine. And here I would have to pause a little to go back to the drafting history of this document. And I have to point out that actually this reference to the genuine character of elections, it did not appear that easy in the text of the protocol, because what the drafters wanted to achieve is a document that would, on the one hand, prevent an authoritarian takeover, which they were witnessing at this time in Eastern Europe, Central and Eastern Europe, but at the same time, they wanted, and they were rather keen on preserving their autonomy of establishing their political system in their country. So this regional norm in the European Convention is a result of very complicated drafting process, which lasted for over 2 years. And that's why it's in the first protocol, not in the main body of the convention. So despite this complicated drafting process, this regional provision also reflects the need for genuine character of elections. And what's this distinction between the mere ability to vote and to stand for office and the actual genuine character of elections? What does it mean? It actually came to the fore in a case before the Inter-American Commission of Human Rights. So this question actually arose early on in electoral rights litigation. So as you can see here, there was certain debate if there can be, if one could disentangle the right to vote and to be elected from the actual substantive obligations towards character elections. So what actually here the government of Mexico, what they wanted to claim was that merely the right to vote and to be elected, merely these rights are immediately enforceable. So merely those rights are binding. So in a sense, as long as people are able to vote and to run for office, actually states could be absolved of responsibility for election fraud and other violations, because the genuine character of elections would be a kind of progressively achievable right. And indeed, there is such a distinction in international human rights law, because, for example, there are absolute rights, such as right to life and prohibition of torture, so which states have to achieve. But then at the same time, there are social economic rights which are inherently dependent on the socio-economic conditions in a given state. So, for example, it would be futile to try and hold a country in sub-Saharan Africa to the same standards in terms of access to housing as would be the case in Finland. So there is this approach that certain rights, those socioeconomic rights, are progressively achievable. So here, the government of Mexico wanted to claim that democracy is also like that. So through trial and error, states would build more perfect democratic governments. However, this interpretation wasn't followed by the Commission. Nonetheless, it's important to underline that still the tension between the two elements of electoral rights, it would be evident in the practice of various global and regional human rights bodies. And what are these bodies? So there is a global human rights body, which is the UN Human Rights Committee. So this is the body which interprets the International Covenant on Civil and Political Rights. So this is actually the jurisdiction where large part of UN member states are party to. Then there is the primary interpreter of the European Convention of Human Rights, the European Court of Human Rights in Strasbourg. So the jurisdiction of this court covers essentially all the European countries with the exception of Belarus. And then there are two other regional human rights bodies, major regions of the world. So there is the Inter-American Court in San Jose, Costa Rica, and its jurisdiction covers Central and Southern American nations. And then there is African Court of Human and People's Rights in Arusha, Tanzania. Its jurisdiction covers a number of African states, but also in both the Inter-American and African system, there is those commissions which are meant to filter certain cases before they go to the court. The European system used to work like that too before 1998, but now all the cases go straight to the court, and that's why, for example, the issue of backlog is always problematic for the Strasbourg court because it has to deal with tens of thousands applications each year. But this was not always the case, because although the European Court of Human Rights was established back in 1959, it didn't have to deal with a proper election case until 1987. This situation can be explained by several factors. First, the scope of the court jurisdiction was very different from what it is today. So if today, as I mentioned earlier, the jurisdiction of the court covers practically all the European countries with very different political regimes, back in the first 3 decades of its existence, the European Court of Human Rights mainly dealt with applications from essentially Western Europe. And apparently in those countries which accepted the jurisdiction of the court back in the era, there was little demand for litigation concerning election rights. When such litigation was initiated, it was primarily by I could say, marginal politicians from the far right, sometimes from the far left, from ethnic minority parties, but not the major political parties. The issues which arose during this kind of litigation, they were also rather specific. So, for example, a number of cases was brought by politicians and voters from the United Kingdom, who argued that the British electoral system, based on the first past the post principle, majoritarian system, so this system was incompatible with the European Convention. But all those applications, they were resoundingly rejected. So the first actual election case came to the European Court of Human Rights only in 1987. However, it couldn't come from a more complicated and problematic political system. So this first election case at the European Court of Human Rights, it dealt with this kind of slice of Belgium. Furthermore, this slice of Flemish region of Belgium, because Belgium there are two major linguistic groups, so the Flemings and the French. But here in this area, there were large numbers of French speakers living in the territories which belong to the Flemish region. And they were able to elect a number of their politicians to the Flemish institutions. And then actually a question arose. So to be able to participate in those Flemish institutions at the time, it was necessary to take an oath in Flemish language. But if a politician would do that, he or she would be unable to participate in French-speaking institutions. So essentially, at the heart of this issue was kind of complicated question of power sharing. So could it be just this black and white division when you can be only part of one set of institutions? Complicated question indeed. However, the European Court of Human Rights chose not to answer. What instead it did was to use this very complicated, I would say, convoluted case as a benchmark for further election cases. So here the court formulated general principle in the sense that there are two kinds of electoral rights. So there is equality of treatment to which both voters and candidates are entitled. But then there is also equality of outcomes to which they are not entitled. So what we can see here is that the European Court of Human Rights actually somewhat models the picture. So instead of this composite idea of electoral rights, which include both the ability to vote at central office and the genuine character of elections, the European Court of Human Rights divides electoral rights into what is protected by the European Convention and into something which is not protected by the Convention. So this interpretation of the Convention, given in this case, what it does is that it actually leaves outside of the scope the review by the court. It leaves outside the scope the outcomes of elections and electoral systems. So as a consequence of this judgment, it is basically futile to challenge any election results in the European Court of Human Rights. Likewise, as we see, it is also futile to challenge any substantive features of electoral system. All those issues have to be resolved at the domestic level. And this judgment actually proved to be very influential, both for domestic courts and other international courts, because for domestic courts, this judgment, the European Court of Human Rights, is the most cited, for example, by the Russian Constitutional Court in election cases. It is also widely cited by other international human rights courts, including the Inter-American Court of Human Rights. So with this judgment, the European Court of Human Rights maybe inadvertently sent the message that only certain elements of electoral rights are worth litigating at the international level. However, that was back in 1987. Since then, the situation with election integrity changed. Most importantly, the perceptions of election integrity became very different. For example, of course, we are well acquainted with those strange, scary images from the US Capitol this January, Trump supporters storming the building. But what is often left behind these images is that why they actually were there. And the reason is actually the obscure way in which election results are finalized in the US. So after all the ballot counting, after all the post-election legal disputes, the US Congress has actually to vote to ratify the election in the Electoral College. So a very obscure procedure, but one which actually becomes the focal point of this distrust towards established democratic institutions. And although we see less dramatic images in other countries which are deemed consolidated democracies, or countries with long democratic history, nonetheless, the overall trend seems to be the same everywhere. So we see trust towards elected institutions, towards electoral procedures falling across the board. In the United States, in France, even in countries like Sweden. So there seems to be a growing issue in the way in which the public perceives the quality of democratic institutions, even in established democracies. But of course, there is another element to the problem with election integrity, and that is, even if a country is on the way to becoming an established consolidated democracy, this progress can always be undone. So what is becoming more and more evident, especially during the past decade, is the so-called democratic decay. So we see that rather than steady march towards democracy, there is something like circuitous zigzagging route. Or sometimes, actually, there is turning back to authoritarian route. But what is important is that even if countries do turn to authoritarian route, it is very different to what it was even during the Cold War. Because during the Cold War, we often had those old school authoritarian dictatorships, where general would just suspend the parliament and end electoral procedures altogether. That was the case, for example, in Greece, after the so-called Black colonels coup, and after that, Greece simply ceased being a member of the Council of Europe, and it just left the jurisdiction of the European Court of Human Rights. So the question of compliance with international human rights obligations in terms of elections, it's never even arose in a serious way. What we see now is completely different. So we see regimes which do hold elections, and these elections are even somewhat competitive. So it's not just one party grabbing all the seats in parliament, or one leader like gaining 99.99% of the vote. No, it's more complicated than that. You see opposition gaining some seats in parliament, some levels of power. However, the overall distribution of power is never in question. So while there are elections, they are not fair. So again, returning to this two sides of electoral rights, the right to vote and to an extent the right to stand for an elected office is respected for this substantive element of electoral rights, so genuine character of elections, it's certainly not respected. So in a way, it's a new phenomenon, especially for the European Court of Human Rights, which never had to deal with it before the end of the Cold War. So how did international human rights courts, and in particular the European Court of Human Rights, deal with this new challenge? Well, in a way, there were three major cases coming from those competitive authoritarian regimes. So first case came back in 2008, and it was brought by two ethnic Kurdish politicians who argued that the electoral threshold in the Turkish parliament was too high. Indeed, at 10%, it was the highest in Europe. As representatives of an ethnic minority party, which represented less than 10% of the population, they felt targeted by this provision of electoral law. However, what the European Court of Human Rights decided was that the threshold was not problematic because there were certain loopholes. For example, different political parties can combine their lists and in a way go around the threshold. So of this judgment certainly showed that the court wasn't ready to rethink its approach from back in 1987. This became even more evident with the subsequent, the case of Communist Party of Russia and others in 2012. So when the court actually decided to take up this case, so in 2010, there was certain fear among the Russian ruling class. For example, my former boss, the president of the Constitutional Court of Russia, Valery Zorkin, argued that by even deciding to take up this case, the European Court of Human Rights was essentially laying a groundwork for a revolution because it was challenging like the basis of state authority. However, any fears which might have been present before the judgment were then dispelled because the court decided that although the state-run media was very biased towards opposition in the run to the election, this wasn't a problem because the opposition still had a measure of visibility. So the court here was adamant, underlined that there is no right to kind of favorable outcome. So that it's basically impossible to argue that a particular outcome of the election was structurally unfair. And in a way, if we look to the experience of other international human rights courts, which I've mentioned earlier, this might have been a wise move on the part of the European Court of Human Rights because there were two examples of international human rights bodies actually engaging in election disputes substantively. So first there was a case in West Africa, where a regional court decided to take up a dispute concerning a parliamentary election in Nigeria. And what happened next was that not only was this court subjected to a massive wave of criticism in Nigerian media, but actually head of states of this regional grouping, they very quickly decided to rethink the procedures of how judges in the courts were appointed. So there was clear message: don't mess with elections, otherwise we will hire somebody else. So that was the case in Western Africa. But even at the UN level, because as I mentioned earlier, there is this UN Human Rights Committee, which deals with complaints from all over the world. Even with this body, there is evidence of open non-compliance in election case. Because as recently as 2018, this UN committee made an injunction that called on authorities in Brazil to reinstate the country's former president in the presidential election. So he was barred from running, and this UN committee essentially argued that he should have been placed on the ballot. And what happened next was that the electoral authority in Brazil explicitly voted to refuse to comply with the injunction in the UN Human Rights Committee. So basically, they told the UN body that you have no jurisdiction here, we don't care what you say. So in a way, this approach of the European Court of Human Rights, it might have saved the court from those kinds of backlash from the states. However, even despite this caution, there is evidence of European Court of Human Rights actually engaging in a kind of deeper overview of cases involving election integrity. And this is primarily evident with this judgment in case of Davidov and others, which deals with election fraud in the city of St. Petersburg during the 2011 election. So what differentiates this case from the previous two was that here the applicants are different. Those are not just professional politicians, but those are also actual voters. And that are not challenging an election outcome or certain features of electoral systems. Instead, they are challenging the way election was run and the way their complaints were rejected. So here, the European Court of Human Rights was very careful not to imply that there was actual election fraud affecting the legitimacy of the results. However, what the court actually did say was that the pattern in which the authorities behaved was indicative of wrongdoing, and this potential wrongdoing was not effectively investigated. So while there is no mention of any fraud in the judgment, and the word fraud never even comes up in the judgment, effectively the court says that still there are certain procedural obligations stemming from the electoral rights in the European Convention. So, in a sense, this judgment actually shows how election integrity can be litigated in international human rights law. So, it's perhaps futile to expect to challenge election outcome directly in international human rights court. However, one can challenge certain practices and the way the authorities behave. So to sum things up, first of all, that although the idea of election integrity largely rests on legal norms, those legal norms are still open to contestation by states, and they are also open to interpretation by international human rights bodies, such as human rights courts. So the very content of those binding norms is still in question. And the way in which the international human rights bodies interpret those norms, it is also guided by certain factors which are connected to the interest of the court itself. So in order to perhaps protect itself from problematic outcomes, for example, the European Court of Human Rights adopts very cautious standard for determining the scope of electoral rights. So the outcomes of elections and the structure of election systems are outside of the scope of electoral rights. However, even with those limitations, there is still room for actual litigation, which can result in a positive judgment for advocates of election integrity. However, to achieve this result, they have to focus on the procedural dimension. So the way election commissions are structured, the way they work, and the way election disputes are resolved. So by focusing on this procedural dimension, advocates of election integrity are more likely to find favorable listeners in international human rights courts. So thank you for your attention, and I will be thrilled to hear your comments, questions, and suggestions.
Thank you so much, Dmitry, for your very detailed talk, and actually for political scientists and those social scientists who actually who are lucky to work with electoral integrity. And speaking of the Russian case and the electoral authoritarian regimes, mostly electoral malpractice rather than integrity. So it's you raised a number of issues that really beg for further investigation. So I had a little bit an easy task to comment on the paper because it really, focus on so many aspects that, have, different, a variety of problems and issues that some of them have been studied quite a lot. Others actually are still kind of seem to be left behind the research agenda. So, and maybe I would like to give our discussion maybe a little bit different spin. So, and just to, maybe to bridge the legal studies, and actually I was surprised how much in common we have. So, and mostly, we have the same jargon, so to speak, and actually they'll also speak to the special subfield of political science or comparative politics, which deals with the impact of international norms, international organizations on domestic politics. So again, there is plenty of room for further scholarly dialogue. Let me just start maybe with some potential pathways in which the discussion can further unfold, and maybe it's a couple of points that really intrigued me. So, and I will maybe intermingle my feedback with some questions because I was genuinely puzzled and I don't really know how to what to start with. So if I were you and if I were to study the same subject. So the first, maybe the main question, I think most of our I feel a bit uneasy of speaking on behalf of our guests and other participants, but let me guess. So I think the first idea that came to all our minds is that what's the point of having these international courts if they are so I would say legally truthless, if not to say politically truthless. So this is maybe the main question that really keeps haunting the whole academic endeavor. And I would be very curious, what is your maybe short answer to this question? So maybe this is one thing. And the second one, as a person who came from quantitatively oriented political science, I'm wondering, so is there any statistics available on the cases which are somehow connected with electoral issues? And what is the percentage or share of the so-called cases that had been accepted for further investigation? And if so what is the percentage or share of outcomes which can be deemed as positive, or partially positive for those who made the pledge? So this is the second question. So because if this share is close to zero, so again, what's the point of even actually handling electoral issues in such institutions as European Court for Human Rights and so on and so forth? So because your extensive overview is plenty of cases when we clearly observe that these international bodies have no opportunity and no instruments to make their decisions, their outcomes, to make the respondent country, especially if they are all authoritarian countries, which really praise their political sovereignty, to make them comply with these decisions. So that's my third question here, actually stems directly from this contention. So what actually can make the respondent states, be them democratic or authoritarian? It makes a big difference, but let's just for a while put them together into the same basket. So what can make them comply with these decisions? I do have a preliminary answer, so let me share. I think you quote Levitsky and Weiss framework, and these guys are also famous for another important framework, which is called linkage and leverage approach. So, and I'm pretty sure you're familiar with that. So, and I think the first answer that comes to my mind is that, okay, those countries that were politically and administratively or economically interested in further integration with the European Union, these countries were much more compliant with the decisions. So, and this is part of the leverage. So in this case, these courts were, and specifically the European Court for Human Rights, was acting as a clearly political instrument. So this is clearly, all electoral issues are intrinsically politicized. And in this case, it was operating as a political instrument rather than a legal one. So, and this is the situation when politics enter the legal rulings and legal proceedings. Speaking of the fourth maybe point, not maybe it's the fourth point, so I wanted to raise is the term of the problem of the uneven playing field, so which also kind of discriminates against certain kind of political actors, being them ethnic minority parties or specific candidates or voters who actually feel that they were deprived of the right to cast a ballot in the proper conditions, and that their opinion actually was not taken into account by the electoral management bodies or political authorities in general. Actually, if I can share any wisdom from the political science again, so is that all electoral systems favor some actors and discriminate against others by definition. So there is no magic bullet or magic ideal electoral system that actually would place all the political actors on the perfectly even playing field if this solution just doesn't exist. And the very choice of electoral formula is an intrinsically political choice. So, and I think it's perfectly understandable why these courts actually try to, avoid making any rulings and taking any stance towards what kind of political rules actually exist in a specific country, because again, it's a domestic political issue by definition. So, and here comes again, I'm going back to the first question. So what's the point of even, taking and considering cases with electoral rights? Because it seems that this global norm actually is not working, at least not working the way it was drafted in the beginning. And finally, I totally agree with you that it's very interesting to look at how these global norms and the interpretation of these norms by global and political and legal actors actually have been changing. So I think this is maybe the most interesting case, how the appearance of new member states and the new members of these conventions and parties, actually how this the use of this norm, because the norm actually has remained exactly the same. So nothing literally, but you can, I don't know, you can correct me if I'm wrong, actually nothing had been changed, right? So, but the very usage of the norm and its implementation have changed dramatically. So, and maybe the last point, so I have the whole page of comments, but I should stop at some point, is that it really, if I were a journalist to describe this whole situation, so I would actually describe this as a very unfortunate story of political outliers or outcasts who are trying to make, in a very unsuccessful and unfortunate manner, any claims. And in most of the cases, literally, but again, you can correct me because you do know the statistics much better. In most of the 90% cases, actually, they are left with nothing. So, and basically all the claims that are related with electoral issues, these are the claims by political outsiders. In the case of Western Europe, it's the right-wing or left-wing or pretty much radical parties, again, outcasts in the political playing field. And in the case of developing countries and countries which we can call competitive authoritarian regimes, so these are the opposition. And in this case, these courts are just institutions of the last resort. So I stop here and thank you so much for your very, I would say, intriguing and detailed overview. And of course, I welcome all our participants to leave comments and to answer questions, so if you wish. And as long as we have no questions and comments so far, so.
Yeah, so I guess I will first, to say that thank you very much for your detailed and thought-provoking comments, because, for example, the first point that you raised, why do we need international human rights court? It's basically the question on which number of legal scholars are working from various angles. So perhaps I could say just only from my limited perspective, primarily on election rights. So basically, we have to be realistic in our expectations of what those courts can do. Of course, they just don't have political leverage to actively interfere in ongoing political disputes, election disputes, so sort of issues of grant politics. And this seems to be a systemic feature, because actually where there are cases that when they try doing this, for example, just didn't have time to mention it due to time constraints, but there is a series of cases from Bosnia and Herzegovina where the European Court of Human Rights essentially said that this kind of very blunt system of power sharing, where if you are not a member of a constituent nation, then basically tough luck for you. So this system was incompatible with the convention, according to the court. However, despite the fact that this compliance with the judgment was made a precondition for further cooperation with the European Union, despite this fact, the judgment wasn't complied with. So even in some situations, even with very developed linkages, still certain election-related issues basically they would be just too heavy lift for an international human rights court. However, even if we leave those kind of more ambitious issues outside of the scope, that still leaves us with something, because, for example, in the field of election dispute resolutions and in general in concerning certain procedural rules, actually the litigation before international human rights courts, particularly the European Court of Human Rights, it can be successful, and there is a growing body of case law in this regard. And furthermore, basically, you raised a very interesting issue about sort of success rate in the International Human Rights Court. And actually, the success rate is not low. So basically, it's not the problem that basically it's court who is rejecting all kinds of complaints concerning elections. It's a bit more complicated. So basically, the more chances of succeeding in Strasbourg court you have, the less impact this judgment is likely to have, because there is a whole slate of judgments concerning the organization of elections in Azerbaijan. So almost 3,000, I guess, by today. However, the problem is that there is almost no evidence of any compliance. So the issue of compliance has been on the agenda for almost a decade, but nothing has visibly changed. So generally, I would agree that basically the kind of politicians who make their case in Strasbourg, they are kind of outcasts in different systems. And I also would agree that the likelihood of compliance is very dependent on linkages with other institutions. But still, I would argue that there is a particular role for the court and even a certain avenue for politicians who want to achieve something. And again, it's primarily confined to this procedural field. And what is intriguing here, that those procedures are often neutral. So if there is a certain degree of political competition, those kind of rules concerning procedures, they can benefit either party. So perhaps a case which I find very interesting in this regard concerns Moldova. So as you probably know, like in recent years, maybe the whole decade, in politics in Moldova has been very turbulent. And in this turbulence, the Constitutional Court of Moldova, which is also a highly politicized institution, it actually found an interesting use to the case law of European Court of Human Rights. So after the last election in Moldova, it was 2019. So then the opposition powers appear to have kind of working majority in parliament, and at first they didn't agree much on anything except for electoral reform. So what the Constitutional Court did, and the Constitutional Court at that point was controlled by the ruling party, which was left in the minority. So the Constitutional Court just, I don't know, maybe they looked into the case law of the European Court of Human Rights, trying to find something, and we did find something. So they found a judgment from 2005 saying that it is fundamentally wrong to change electoral rules just a few months before the electoral campaign, because basically this allows to discriminate against the upcoming parties and to cement the advantages of the ruling. So the Constitutional Court interpreted this judgment in a very broad fashion, saying that, okay, if there is any electoral reform, and after that the parliament is dissolved, any electoral reform should enter in force not in those snap elections, but in the election after that. So in that situation, that would clearly benefit the ruling party, although it was in the minority. So basically, the opposition parties couldn't change the electoral system to their advantage. So I think what certainly the European Court of Human Rights is trying to do is to produce such judgments which are kind of politically neutral and which can be used by different political forces. And again, I couldn't agree more that indeed uneven playing field is kind of fundamental feature of electoral politics, and international courts certainly, at least Strasbourg Court, certainly knows that and tries to use it. And yeah, last but not the least, of course, it's a very good point. You made a very good point on kind of how the interpretation of the electoral rights norms changed with the accession of the new member states. This is indeed a kind of fascinating and ongoing process. And it's clear that the interpretation does change in many different ways. So again, thank you very much for your comments. Something to think of and work on.
Okay, thank you, Dmitry, for your very detailed answer. But as long as, if I can continue this conversation, and we have a little bit of time left, I just maybe wanted to react and maybe to keep going with the discussion a little bit further. It's interesting to learn that the success rate is not as low as we thought. So, and I think this is a fascinating topic to study, even by quantitative means. So I think this is a realm and interesting subfield that where actually legal scientists and political scientists can come together and maybe cooperate, because this is this is a kind of a part of the evidence that can show how different types of cases or types of claimants or types of respondent states or in different parties, how they have changed over time depending on what kind of parties actually were taking part in litigation, and starting maybe from the foundation of the institution and then until the most recent point possible. So I think it's one way actually to see how these reinterpretation of the global norms actually have been occurring and what are the reasons and what are the correlates of that. So I think one very important thing we kind of overlooked here is the role of international observers, because these people, they bring empirical and legal evidence to the courts, which can be relied upon by lawyers and by advocates, by claimants. So, and I'm just wondering to what extent the international organizations like OEC observers, domestic monitors, what kind of role they play in these litigations, if there is any role. So are there reports, or I mean their personal appearance, if there is such a practice, of course. So to what extent it's happening in the courts. It's one thing, and maybe the second question I have, since our seminars are focusing on Russia and post-Soviet space mostly. So what about Russian cases? Because in your paper, and fortunately our audience actually didn't have a chance to read it, but I can just briefly mention that Russia was, some Russian opposition parties, the Communist Party, if I'm not mistaken, Alexei Navalny and his supporters, and some other people, they tried to make cases with the European Court. And I'm just wondering, so are these cases are deemed to be legally successful in terms of their outcomes? And does the Russian state comply with these rulings? And if yes, why is it the case? Because what's the point for an autocrat to be a part of this club and to comply with the decisions actually that would clearly undermine the regime's position, or maybe it would cast a shadow on the reputation, if these are very minor concessions, so to speak, because as you said, so the propensity for a case to be successful is how ambitious the claim is. If it's about pretty minor things, so this is something that can be easily tackled and negotiated with the state, and states maybe comply with these rulings more voluntarily or willingly. So, but at the same time, it may come, especially for these competitive authoritarian regimes like Turkey, you mentioned Azerbaijan, Russia. So all these countries have very ambitious personalist political leaders. And if there is any case when the state had to make a concession, so it could be seen as a political failure. To what extent these issues are politicized, they come to the fore in the domestic media. If you, of course, it goes beyond your the scope of your research, but maybe you have something to say about that. So, and I stop here. Thank you.
Oh, thank you very much. Very intriguing question, because I've done some research specifically on the role of international observers in the case law of the Strasbourg Court, and what can I generalize from what I've found is that observers and their reports, they are not seen by judges as kind of factual evidence. However, their reports are relied upon to establish certain patterns. For example, if the Strasbourg Court makes a judgment concerning, for example, elections in Azerbaijan or Georgia, and if there is a certain systemic issue which is raised in this particular case, and it's also found in observer reports, then of course the court will make reference to those reports, and this would be kind of evidence of a certain systemic issue. However, again, it is not seen as evidence that a particular election was valid or not, that a particular election system was worse than others, and so on. So those reports by observers, they do play a part, but it depends on circumstances of particular case. Generally, I would say the worse the situation is, the more likely the Strasbourg court is to cite observer mission report. Although perhaps the most bizarre, shall I say, reference to election observation mission was actually in case not directly connected with elections. So concerned protests in Hungary back, I think, in 2002. So the only time Viktor Orban lost an election. He never repeated this mistake. And there were some protests by Orban supporters, and they were even kind of suppressed by the police. In judgment concerning those protests, the court mentioned in passing that, okay, observers noted nothing fishy, so perhaps your protests, which kind of shut down the whole city of Budapest, maybe they were a little bit over the top, you know. So that was kind of an interesting reliance on the International Observer report, but I think that was the only such case. Turning to the question concerning the Russian opposition, what is interesting here is that I would say that in the cases concerning opposition, they mostly come not from not mostly connected with election issues, but rather kind of more physical types of human rights violations. So they are mostly associated with mass protests, detention, and other sort of other forms of physical suppression. So in a sense, this is kind of an easier path for human rights court because there is kind of long history of international human rights courts highlighting issues of torture, persecution of the opposition, illegal detention. So this was actually well developed even during the Cold War. So here, on the one hand, international human rights courts, they feel that they stand on firm ground, and that's why, for example, recently the Strasbourg court issued a resolution saying that Alexei Navalny should flee immediately, although of course they knew that Russia would not comply with that. Still, they issued such a resolution because there is kind of long history before on such statements, and they kind of feel that they are on the firmer ground. In the elections, well, as I argue, there is kind of less firmer ground. That's why the approach is more cautious. For example, there is no chance that Strasbourg court would issue kind of preliminary kind of decision saying that you should, for example, overturn your election results, or you should not sit like those people in parliament. This is not likely to happen. But so indeed, in election cases, it's more just like you said, it's more like kind of more minor issues, and sometimes states do comply with those judgments because stakes are indeed low. So it's kind of incremental approach. So kind of small scale findings of violations, which maybe would change something on the ground, or maybe that's actually what I'm still looking into. So what perhaps, what is important to note is that there is evident divergence between more classical human rights cases concerning opposition and those election cases. So in the first case, the courts feel that they have firmer ground, that they can raise their voice. In the latter category, they are not so sure. So that is, I think, degree of difference between the two.
Okay, so thank you very much. So I think that was very instructive and detailed. So, and this seminar will be posted online with subtitles in a while. So please check out our blog, Electoral Malpractice, and with political concepts in Russian and beyond. So you can actually find it on the Aleksanteri website, the link to our blog, and if you just Google it. So thank you so much for your participation. Thank you, Dmitry, for your talk and for the discussion. So, and hope to see you next time.